Hello everyone. Welcome to Aussizz Conclave 2024. My name is Alpha and I'm your session coordinator for this topic. We hope you're excited to know all about partner visa. Now, get ready to meet the expert who will guide you through your journey today. Today's migration agent is Ms. Yuting Chen. She is a professional registered migration agent and qualified education agent counselor. With 8 years of experience in the migration and education industry, she has assisted thousands of customers with various types of Australian visa matters. That's all, folks. Relax and enjoy the session. You are in good hands. Let's get started. Now, I'll be handing over to Ms. Yuting Chen to start the session. Thank you very much.
Thanks, Alpha, for your introduction. Hello, everyone. Happy Friday. My name is Yuting, and I'm the OMARA agent. I'm located in Perth, in Western Australia. So today is the last day of our one-week conclave. It's my pleasure to give us some information about the partner visa. As everyone should know, partner visa is one of the most crucial and also one of the most popular type of family visas to Australia. So partner visa, it is for whom? So it is for the spouse of an Australian citizen, Australian permanent resident, or an eligible New Zealand citizen, which means if you are married, or if you are in de facto relationship, or if you have been engaged with an eligible sponsor, you will be able to apply one type of the partner visas, which I will introduce to you. So let's start. So the partner visa can be classified into 3 types, depending on the location of the applicant and also the status of your marriage. So let's say if you are already married to an eligible sponsor who are Australian citizen, PR, or eligible New Zealand citizen, then depends on the applicant's location, the partner visa can be classified into onshore or offshore, which means if at the time when you lodge the application, if you're onshore, if you're in Australia, you can apply for the subclass 820-801 visa, which is onshore partner visa. Alternatively, if you are offshore, for some reason you cannot come here or you don't want to, then you can apply for the offshore partner visa, subclass 309-100. And there is another type of partner visa. It's called prospective marriage visa. It is also offshore application only. So the applicant must be offshore when lodging the visa application. Subclass 300. This visa is for the spouse who has not been married or meet the definition of de facto relationship with the eligible sponsor, while who is planning to marry in short future. So in this case, the spouse can apply for this offshore prospective marriage visa, wait the visa to be granted, and once the visa is granted, within certain period of time, they need to come to Australia, get married with your sponsor, then within a certain period of time, you can continue applying for the onshore partner visa, subclass 820-801, then finally settle down in Australia. So these are the 3 different types of partner visas. In general, definitely, if you are already in Australia or you got a visa, you got an eligible visa to come to Australia, then onshore partner visa is the most popular partner visa type. Why? Because it got lots of benefits. Okay, so I made a very simple flow chart for you to have a better understanding of the partner visa procedure. So let's say if you're onshore, when you're lodging the partner visa, then the partner visa is a 2 stages PR visa. The first stage is TR, is subclass 820. So when you apply for the partner visa onshore, you apply for subclass 820, which is a temporary resident visa. Once this subclass 820 visa is granted, then you will be, it's kind of like, actually this subclass 820 visa, it does not have a validity or it does not have an expiry date. So when can you move to the next step, which is the subclass 801 PR visa application? It's 2 years immediate from the time 2 years from the stage 1 subclass 820 visa application. So let's say today is 30th, it's 28th of June, 2024. If you launch the stage 1 subclass 820 visa application onshore, then when is your earliest time for you to be eligible for the stage 2 subclass 801 visa application? It's going to be 28th of June, 2026. Okay, so it doesn't really matter when you got the stage 1 subclass 820 visa grant. As long as it comes to 2 years after, since your initial application, you will be eligible for stage 2 801 visa application. Currently, the partner visa, onshore partner visa processing time for the stage 1, it takes a bit longer. Well, the reason is also because currently it's coming to the end of the financial year. So all of the visa processing time is getting a bit delayed, getting a bit longer. So now if you check the estimated processing time, you can see 50% of the 820 visa applications could be finalized in 18 months. Okay, 50%, half of the applications could be finalized in 18 months. And when it comes to the stage 2, the subclass 801 visa application, that could be finalized in another 6 to 10 months. So from the initial application till the end, till you final get PR, I would say you might need to wait for at least around 2.5 years to 3 years time. But why am I saying onshore partner visa is much better, or if you can launch onshore partner visa rather than the other type of partner visa? It is because as long as you launch the stage 1 partner visa onshore, you will get lots of benefits. So the first benefit is because this is onshore application, you will get the bridging visa to lawfully stay in Australia for the visa decision. And also, this bridging visa will give you no condition. What does it mean? That means once this bridging visa comes into effect, you will get full work right. You can, or if you want to study, you have the study right as well. So there is no condition, no study or work condition on this bridging visa because of onshore partner visa applications. But of course, if you want to travel overseas, you still have to apply for the bridging visa bay to get the travel rights. Okay, so the second benefit is once you launch the onshore partner visa, you will be able to apply for the interim Medicare card. Okay, so you will get access to the Australia free public health service, which is a big benefit. And in terms of the offshore partner visas, which we refer to the offshore partner visa, subclass 309-100, or the prospective visas, these two visas will be suitable to. Okay, those visas are suitable to people who have no choice, or for some reason they have to launch the visa from offshore. Okay, so I make this flow chart for you to identify which subclass or which option is the best option for you. Let's say if you are married. No, sorry, I'll start from the very left side. If you're not married, like what I say, if you're not married and also you don't meet the de facto relationship criterion, you have no choice. You have to go for the subclass 300 prospective marriage visa, and you can only apply for this visa from offshore. So here I would like to explain more about the definition of de facto relationship in partner visa applications. So in partner visa applications, the de facto relationship means you need to show evidence. You need to provide evidence to show that you have been living together with your sponsor for at least 12 months before the application. Okay, so which means you should have been living together for at least 12 months, and you need to provide enough evidence to support your claim. Okay, so if let's say if this couple, one is in Australia and the other one is offshore, unfortunately, you have to either get married, or if you're not thinking to get married, then you could only go ahead with this prospective marriage visa, because you will not meet the de facto relationship requirements because you haven't been living together for 12 months. All right. So this prospective marriage visa, currently the processing time is around 12 months for half of the applications, but it can be even longer. So depending on the whether the evidences you provide is sufficient enough. Once the prospective visa is granted, the applicant can come to Australia and to arrange the marriage with the sponsor. Once you get married, you can continue applying for the onshore partner visa subclass 820 and finally get PR through the subclass 801 visa. Alternatively, if you're already married or you make the de facto relationship requirement with your sponsor, then you can choose to try to apply for the visitor visa first, or whatever visa options you have. Okay, so you can try to apply for a visitor visa. If you can get the visitor visa grant, then the next thing you should check is whether there is an 8503 conditions applies on your visa grant. 8503 condition is no further stay condition. So if there is no such 8503 conditions applied on your visitor visa, that means you will be eligible to apply for an onshore visa. So you can come here, travel to Australia, and when you're ready, apply for this subclass 820 onshore partner visa, and then you'll get bridging visa A to lawfully stay in Australia until the visa decision. However, if there is an 8503 condition applies, then that means, unfortunately, even if you travel to Australia, you will be prevented from applying. You will be prevented from applying for another onshore partner visa. So in this case, you could only apply for the another different type of partner visa, which is the offshore partner visa subclass 309. So the third type of if there is no way for you to come to Australia, not a problem. You still can apply for the offshore partner visa subclass 309. But in that case, you can only come to Australia after the TR, after this 309 visa is granted. All right, so once it is granted, you can feel free to travel to Australia, stay with your sponsor. Same as the procedure of the onshore partner visa, 2 years after the initial application of the offshore partner visa stage 1, you will be eligible for the stage 2 subclass 100 visa application, which is a PR application. And at that time, you can straight away launch this visa while onshore. Okay, so I'll quickly go to the first two pages. Just now I was talking about the partner visa types. Depending on your location, the applicant's location, and depending on the marriage status, whether you're married, you're de facto, or you are just in fiancé relationship, it can be divided into onshore, offshore partner visa, or offshore prospective marriage visa. And this is the flow chart for the onshore partner visa. So the first stage is 820 visa application. 2 years from the initial application, you can go ahead with the stage 2, 801 PR visa application. So from the initial application to the final PR grant, you might need to wait for at least 2.5 years or even a bit longer. But like what I say, from the time you launch the 820 visa, as long as you launched it, you will get bridging visa A. So you'll be safe. You'll be lawfully staying here until the visa decision, and also you can apply for the interim Medicare card. So just now we've been talking about the relationship, like what type of relationship is eligible for this partner visa. So here I listed out the options. First of all, marriage. Okay, if you are legally married, you're officially married and already got the marriage certificate, no problem. You can go ahead with the onshore offshore partner visa straight away. Alternatively, if you are not yet married, that is also fine, as long as you have been living together for 12 months or more, and you can provide the evidence, the official evidence to show your de facto relationship. You can also apply for the onshore or offshore partner visa as de facto. Option three is only available for onshore partner visa, and it is only available in certain states. Okay, not every state have this service, which is relationship registration. So in certain states, such as I believe in Victoria, New South Wales, they do have this official registration of the relationship. So if the couple, they can register their relationship with the relevant state authority, then they can straight away lodge the partner visa without getting married, nor also without showing that they have been living together for 12 months. However, this is only available in certain states. For example, I'm in Western Australia. However, Western Australia does not have this service. We don't have relationship registration, unfortunately. Okay, now we come to the detailed requirements for this partner visa, because lots of people, they know about partner visa. They know that they have to get married or they have to be living together for 12 months or more, but they are unsure what documents they should provide along with the application. Yeah, so like what I said, not many people they are aware of what type of documents or through which aspects the Department of Home Affairs, they will assess your relationship. So of course, if you just provide the evidence of living together for 12 months or just a piece of official marriage certificate, that's not enough. Okay, that's not enough. Well, being living together for 12 months or more, or have already married, it is just meeting the eligible. Okay, it is just meeting the prerequisite for you to lodge the application. But after you lodge the application, immigration is still, they need you to provide more evidence to show this relationship is true. Okay, it is genuine. And also you need to try to provide as much information as possible to show the case officer that your relationship will definitely be continuing. So genuineness and continuation of the relationship are the most crucial points that you need to convince immigration. So usually immigration, they will assess your relationship from four different aspects. The first one is social awareness of the relationship. So what does it mean? Social awareness, make it simple. It means whether you have already announced your relationship, or you have told the public about the relationship of you and your spouse. So whether they are aware of you have a boyfriend, or sorry, having a de facto, or you're married, whether you have shown your partner to everyone. So this is called social awareness of the relationship. So in terms of these parts, what documents usually you can provide? First of all, it's the photos. Okay, photos, definitely. If it's a true relationship, you should keep lots of photos from the beginning of your relationship. Yeah, so, but in terms of the photos, I don't suggest you to only provide the selfie of you and your spouse. So these photos should be taken either in some special occasion, for example, in your anniversary, in any public holiday, in your joint trip, in birthday, or photos with your friends and family hanging out. So some special photos rather than just selfie taken at home. Because if you only provide like hundreds, you even provide hundreds or thousands of selfie with your spouse, that doesn't make any sense. All right, anyone, if they want to make fraudulent information, they can take selfie just in one day by changing different costumes. Okay. All right, social awareness. Apart from the photos, you also, if you have any joint trip before, then provide the joint travel tickets, the hotel booking. All of these are very good proof. And also, a very important document is Form 888. So you must provide at least 2 Form 888 along with the application. So this Form 888 must be completed and signed by an Australian citizen or PR who have been knowing you and your spouse. So first of all, it must be completed by Australian citizen or PR. And secondly, this person should know both of you and your spouse. So Form 888, at least 2, the more the better. The second aspect that immigration would like to check is the financial commitment. So financial commitment means whether you and your spouse have already got any joint financial ties. For example, any joint bank statements, or if you've got any like joint property, whether you have purchased the house together and whether the house is under both of your names, or if you're on rental, whether you can provide a joint lease agreement, all of this. Okay, or if you have any other joint assets, joint property, all of this is considered as financial commitments. So usually, once the couple live together, they will start to share the costs, the daily expenses. So in this case, I would suggest every one of you who have just started the relationship or who have been living together recently to start to set up the joint bank account. And be careful, this joint bank account should be really used for your daily expenses instead of just opening there and without using. So an empty joint bank account, it shows nothing. The immigration they wants to see whether you have been really putting your money together, and also whether you are really using this joint bank account for the daily expenses, such as the utility bills, such as the petrol, the groceries, all of this. Okay, all of this. You don't have to put all of the money together, but you should regularly, okay, periodically deposit the money into this joint bank account. Living arrangement. So what does living arrangement refer to? It refers to, for example, the utility bills, okay, again, or the lease agreement, whether you have been living together, right? So if you have been living together, you should provide enough documents to show your living arrangement. I am living together with my sponsor. What can you show? If you have lease agreement, provide a lease agreement. If you purchase the house, if you live in your own house, then provide the joint ownership of the property. And also the utility bills are very good proof. Alternatively, at least you should be able to show some letters or correspondences from the third party, like from sent to either you or your spouse, but with the same address. Okay, so all of this can be a good proof to show the living arrangement. Last but not least, mutual commitment. So mutual commitment usually refers to your statutory declaration or refers to your relationship of the relationship statement. So you should write a detailed statement to the Department of Home Affairs explaining or describing your relationship history. And also you should try to provide as much details as possible to convince immigration that, okay, my relationship with my sponsor, with my spouse is definitely genuine and continuing. So mutual commitment, it's most of the time it's related to the writing statements from you and your spouse. So at this part, you need to try to give as much details as possible about your relationship, about your love story. So this is a love story. Don't be shy to give details to the case officer. Okay, don't be shy. So apart from the like needing to provide enough documents to show your relationship is genuine and ongoing, other requirement for this partner visa, of course, it involves the health examination as well as character requirements, which is the same as which applies to almost all types of Australian visas. So you have to pass the health examination, and also you need to provide national police check. Okay, you need to provide national police check for all of the country, for any country that you have been living. You have spent a total of 12 months or more cumulatively in the past 10 years since turning 16 years old. Okay, you have to provide the national police check as well as Australian federal police check. If you have been living in Australia cumulatively for 12 months in the past 10 years since turning 16 years old. And be careful, Australian federal police check. Okay, there are so many different police check in Australia, you must apply for the Australian Federal Police Check rather than any state police force and any police check issued by the states. Okay, that's a wrong one. And also, even for Australian Federal Police Check, you must choose the right type. Okay, it must be for the immigration and citizenship application, not for any other type. Okay, so if you need any more information, feel free to contact me personally, and I'll give you more information. All right, so what happens after the grant of a TR visa? I believe I already covered this page in previous talking, but I'll just repeat again. While on the first, once you're granted for the TR visa, either onshore TR or offshore TR, you can stay in Australia. Okay, you can travel to Australia immediately, and you will get full work right, and also you will get the Medicare. Of course, for the onshore partner visa 820, as long as you lodge the onshore partner visa, you will get the full work right only if the bridging visa comes into effect, which means, let's say if you are currently on 485 visa, no, I'll make another difference. If you're currently on visitor visa, okay, and the visitor visa will be valid for three months. For each state. And in the second month of reaching Australia, you apply for this subclass 820 visa. Yes, you will immediately get a bridging visa, but be careful, this bridging visa will not come into effect until your current substantial visa, which is visitor visa, expires. So when will the visitor visa expires? It's the 3 months since you arrive Australia. So this bridging visa, because of the onshore partner visa application, will only come into effect when the visitor visa expires, which also means in the first 3 months while holding the visitor visa, definitely you cannot work. Okay, you could only get the full work right when your bridging visa, because of the partner visa application, comes into effect. And I always suggest you, once you lodge the visa and once you get the bridging visa, please double check the visa condition. Okay, please double check just to avoid any misunderstanding or any unawareness. Then to just try not to breach any visa condition. And Medicare, yes, for both 820 and 309 visa, once you get it, you will get Medicare card. And for 820, once you launch the 820 visa, you can apply for the interim Medicare. Yeah, next. Yeah. So once it comes to 2 years since your initial partner visa application, you will be eligible for the stage 2 subclass 801/100 visa application. You will need to show that since you were granted the stage 1 partner visa, you and your sponsor have continued to be married or de facto partner, which means the relationship, you must show evidence to show, provide evidence to show immigration that your relationship is still ongoing. And also, this relationship is genuine. And again, you have to show immigration again that you are committed to a shared life, excluding other partners. So yes, we can simply interpret this stage 2 application as a repeat application of the stage 1. Pretty much that is a repeat application. You need to provide evidence to show that since being granted the stage 1 TR visa application, your relationship is still ongoing and genuine, which means all of the evidences you submit along with the stage 2 application should be since the time of getting the TR visa. Like photos, you need to provide more photos. Joint bank statement, you need to provide more, like the most recent joint bank statement, or whether since getting the TR visa, whether you have purchased the house, you have any joint property, you need to continue to provide those documents. Next, yeah. So yes, like what I say, you can apply for the stage 2 PR partner visa at least 2 years from the date of initial application. You will also need to update the department if your circumstances changed. So what type of circumstances change? That means like your contact details, you renewed your passport. You need to tell immigration immediately because the passport number will be reflected on your visa, on your visa letter. Your marital or de facto status, if at the time when you get TR, you were just in de facto, but after that you get married, then you should inform immigration immediately about this change of marital status. The birth of a child, of course, or if your relationship has ended due to domestic violence, you definitely need to inform immigration as well. Because if your relationship is ended, normally as an applicant, you have already lost the eligibility. You will be no longer eligible for this partner visa. But if the relationship is ended due to domestic violence and you can provide enough evidence to show this, then you might still be able to get the final PR, case by case. Next, okay, so it comes to the second part, which is the prospective marriage visa. But I believe I've covered most of the information just now. So again, prospective marriage visa is suitable for people who are not yet married and also who haven't been living together for 12 months or more. Okay, so this is also known as a fiancé visa. This visa, it will give you 9 to 15 months. So the duration ranges from 9 to 15 months. Once the visa is granted, you can come to Australia. Okay, you must enter Australia before the date specified on the visa. So this 300 visa, prospective marriage visa, it will give you a certain date on the visa grant letter telling you must arrive by date. It's called must arrive by date, which means you must arrive in Australia latest by that date. Otherwise, this visa will be expired. Okay, so once you come to Australia, you must get married before this visa expires. Then you can continue to apply for the onshore partner visa. Next. Okay, so that's end of my presentation. Thanks for watching.
So thank you very much for joining the session and for your time. And yeah, have a good weekend.
Thank you, everyone. Thank you, Alpha.
Thank you for the session.
Thanks.
Yeah.
Bye. Have a nice weekend.
You too. Bye.